All right, well, thanks for coming out for a little chat about what I do at the Institute for Justice. As Pat said, I am Jeff Rose. I'm a senior attorney with the Institute, which is based in Washington, D.C. It is a libertarian, public interest law firm. What that means, libertarian to us is principled constitutional limits on the power of government. This is, we're not associated with the Libertarian Party or libertarian politics, and we're not conservative, we're not liberal, we're something different. And so I hope my talk will provoke some interesting thoughts and ideas for you, no matter where you sit on the political spectrum. So we represent clients for free in strategic constitutional cases that are designed to vindicate not only their rights, but through creating legal precedent, vindicate the rights of everybody. That means that we're not legal aid. We don't take your case just because you have a problem. We're looking for very special kinds of cases that we can design and litigate from the trial court all the way to the U.S. Supreme Court or to a state Supreme Court. We focus on 4 areas: property rights, economic liberty, free speech, and educational choice, school choice. And these are really the cornerstones of what at IJ they call the American dream. These are constitutional principles and cultural principles that everyone can affirm, whether you're on the right or on the left. We want our cases to appeal to everybody. We don't represent sort of pariahs. We don't represent abortionists, pornographers. We don't represent neo-Nazis. Not that they don't deserve representation and people can do it, but that's just not what we do at IJ. And what we're interested in vindicating is the right not to be subject to the illegitimate use of government power, and that power constrained by the judiciary under constitutional principles. So, how do I know what I want to do at IJ? How do I know what kind of case is a strategic case that I should do and that we should do at IJ? Well, let's take a step back and think about where laws come from and what laws that we want to challenge on constitutional grounds. There's a huge proliferation of laws. Every day new laws are written. There are local laws, there are municipal laws, county laws, there are state and provincial laws, there are federal laws, there are federal and provincial regulations, administrative regulations. They're all coming from somewhere, and where are they coming from? Now, when I was growing up, there was this thing called Schoolhouse Rock on TV that had, I am a bill, I'm only a bill. Some of you are probably too young to have seen that, but you probably have a nice story of civic engagement in which, someone sees a need, something important that has to be done for society, and then the legislator sort of, slams down the phone, spins around in his chair and starts typing up that bill that's going to save society from this particular evil that the public is crying out to fix. It's a nice story. It happens once in a while. I'm not going to say it doesn't happen, but it doesn't happen as often as you might think. And the explanation is in something called public choice economics. And the basic insight of public choice theory is that political power is a scarce and valuable resource, and people will pay to obtain it. And I don't mean pay just in the sense of bribes. I mean devote their time, their expertise, their money to acquiring information that is necessary to secure political power. Politicians run for office so they can get political power. Companies lobby the government so that they can obtain political power. And so the question is, laws come from the people who control political power. Now, how do they get it? So I'm going to ask you a question. I think everybody here who has a job or has had a job knows how much you make. Everybody who's ever worked knows what they're paying you. Do you know who your alderman is? Do you know who your MP is? Do you know who your MLA is? Maybe some people do, but maybe not so much. Do you know, this is an example from a talk from the other day, do you know what fraction of the price of an egg is the result of protectionist subsidies that the Canadian government enforces to ensure that foreign eggs aren't available on the Canadian market? You probably don't know what that is. Someone knows. Do you know who the Minister of Agriculture is? No. Someone knows. And the someone is the guy who's producing the eggs. The guy who's producing the eggs knows who the Agriculture Minister is, knows who all the Agriculture Minister's functionaries are, and that guy also knows the fractional price of the egg that is the result of government tariffs, subsidies, taxes, whatever. And so the point of public choice economics is that when rules are created that regulate the sale of eggs, who is going to be at an advantage? People like you who don't know anything about the price of eggs, or the guy who's producing the eggs and has the incentive to obtain the information and expertise necessary to manipulate the political system in his favor. In the wake of the 2008 financial crisis, Congress passed and the President signed a bill called DoddFrank. It was sponsored by Barney Frank of Massachusetts and Chris Dodd of Connecticut, and it was intended to reform the financial system. Does anybody know what's in Dodd-Frank? Maybe you haven't even heard of it. Yeah, that was one like something, and like to the extent you know, you have this like vague idea that maybe something happened that might be good for consumers. But nobody actually knows what's in it, right? I mean, I don't know what's in it. But you know who knows what's in it? I guarantee you that the people who run Goldman Sachs and all the other investment bankers know what's in it. Their lawyers know what's in it, their lobbyists know what's in it, and they knew what was in the proposed bills before they were passed. And you can bet that those people were spending tens, maybe hundreds of millions of dollars on lobbying to make sure that when Dodd-Frank came out, it would have all kinds of attributes that would be appealing to the public, things like consumer protection and stuff like that, but deep in the meat of it, you think it's going to stop those people from making the money they were making before or doing the things they were doing before? Improbable. Why? Because investment bankers and their lawyers and lobbyists have money, time, expertise to make sure that when laws are passed, they are passed in ways that advantage them. Now, you might say, oh, should I blame the politicians? Let's blame the politicians. Let's blame Frank and Dodd and everybody else in Congress and President Obama. It's their fault, but don't blame them. It's in their nature. Politicians want to rule. Politicians want to exercise political power. The government is a machine for moving trillions of dollars from one set of hands to another. And so they just do what politicians do. And investment bankers do what investment bankers do. And so how do we protect ourselves? How do we protect our rights in a system in which all of the incentives are to generate things that often, we can all come up with counterexamples. I'm not saying that everything is bad or everything is entirely self-interested, but an enormous amount of property and economic and social regulation is driven by this public choice dynamic that I'm describing. You know why the war on drugs is going to be very difficult in the US to dismantle? Because prison guard unions, police unions, the people who build prisons, the people who maintain them, there are entire bureaucracies in every state in the federal government that are devoted to maintaining the prison system and incarcerating like 1.2 million people. That is very difficult to dismantle when you have all of these financial incentives that sustain and perpetuate the status quo. So what I'm trying to suggest is that we have to take a step back. To understand strategic constitutional litigation, one of the things we have to do is take a step back from the entirely idealistic vision of government. And in fact, we have democracy not because democracy is fantastic, but because it is the least worst alternative. The world is filled and history is filled with people, and this society is too, although fortunately we sort of keep them out of power, but the world is filled with people who, if given the opportunity, would take your liberty from you and make you do the things that they want to do. And so the purpose of democracy is to allow society to function and prosper, but do so in a way that holds political leaders accountable and tries to minimize the damage that bad people can do to society. All right, so the public choice dynamic that I'm talking about, when laws are passed principally for the financial or otherwise parochial advantage of particular special interests, generally speaking, I think that's an illegitimate use of government power. We do not convene governments to enforce arbitrary laws against us that benefit very special people and injure the rest of us. And so that illegitimate exercise of government power is fundamentally what I'm trying to fight at IJ, at the Institute for Justice, and what we're trying to do with our property rights practice and our economic liberty practice. Sorry. So I was saying a minute ago, don't blame politicians. So where do we turn? The constitutional structure is a little bit different in Canada, but in the United States, more strongly, we turn to the courts. That's the actual institution the branch of government, who has the cardinal duty of enforcing our rights. The judiciary is supposed to be a bulwark of liberty against political power, and in particular against arbitrary political power. And the reason why the judiciary is important is because rights without an institution that will enforce them, those rights are meaningless. So it doesn't matter whether to say that you have free speech rights, but you're in a country where those free speech rights aren't actually enforced. So what does constitutional law look like in the United States that I'm actually now thinking, okay, I want to challenge this public choice stuff. When I see people getting ripped off, when I see people being prevented from working or prevented from owning property, in the case that Pat talked about, for example, the Community Youth Athletic Center. This is a great example. Two of my clients, Carlos Barragan, senior and junior, father and son, live in a rundown part of San Diego called National City. It's actually a city just outside. And there are gangs and kids who are just running around all the time, and they don't have anything to do except get in trouble. They come from broken homes, there's drugs, that kind of thing. So they say, you know what, we're going to hang a punching bag in our backyard, and any kid who wants to come after school to a safe place can come to our house, and we'll train you to be a boxer. And this part of National City is almost entirely Hispanic, of Mexican origin, and so there's a big boxing tradition in Mexican culture. And the Barragans said, you have to come every day. You cannot come and stay with us 3 days a week and then go out and cause trouble the other 2 days a week. So you come every day and you have to show us your report card. You have to study and you have to succeed in school. So the Barragans were teaching boxing in their backyard. And they had volunteer coaches and everybody came. It was great. So one day a local news station did a story about them. And UPS gave them a community grant, about $100,000 in order to buy equipment. And the Barragans said, well, this is great, but we have enough equipment. We can't really buy equipment. What we'd like to do is buy a gym somewhere so we don't have to do it in our backyard. And at one point, they actually rented a garage from a neighbor. So nobody will give them a loan because this isn't a money-making enterprise. So they go to the Barona band, the Barona Indian band, who operate a casino outside of San Diego. They sat down with the tribal elders and said, will you lend us some money that we can combine with the UPS money so we can open a gym for these kids? We don't know how we'll pay you back, but we will. So the Barona elders go back in a room, sit around and chat for a little while, come back out, say, here's $175,000. It's not a loan. Go forth and do good works with it. So the Barragans, just these two guys with blue-collar jobs, suddenly had $250,000. And they went and bought an abandoned gun store in downtown National City. And then with the rest of their buddies in construction and with donated materials, they refurbished it and turned it into a boxing gym for kids. It's absolutely free. And the gym has been running now since they opened there in 2001. Kids don't pay, and a number of the kids are actually sentenced there as a condition of their probation. They have to go to the gym, and they go every day. There's a study room in the back. They have tutoring in addition to the training. And so it's great. So what does National City do? 2005, what's going on in California? Housing prices are skyrocketing. People are flipping houses like crazy. And a developer comes along and says, you know what? There's actually a commuter rail line here, and housing prices in San Diego are crazy. So I'm thinking I want to put up a kind of a luxury condo building, and it'd be a perfect place to do that? Right where that gym is. And so the developer persuades the city of National City to use the power of eminent domain to seize the gym, give their land to the developer. Now, the developer would have to pay the gym something, but the gym didn't want to leave. And under the U.S. Constitution and the California Constitution, there are two limits on the power of eminent domain. It's actually called expropriation in Canada, but I'll continue to say eminent domain. The taking has to be for a public use, and there has to be just compensation. And the gym just said, we're not leaving. This isn't A, we don't want to leave. B, this isn't a public use. But the gym had no money. So I realized when I heard about this that this is a perfect case. This is a perfect case for IJ because this is classic public choice dynamic. This is sort of a financial interest teaming up with the government to exploit the law, to take away the property of an ordinary set of people in order to build luxury condos for yuppies. That's wrong. We all understand that that's wrong. But winning that case, we actually have we had a huge trial. This case has been going on for several years. We had a huge trial. We won. And then it's up on appeal. And now, actually, in a week, we won almost everything on appeal, too. But there's one constitutional issue. We're now going to file a petition with the California Supreme Court in a week and a half. These cases are extremely difficult to win. And here's where the crash course in American constitutional law comes from. And I'll explain to you why these cases are so hard to win, although we managed to do them. I'm going to talk about the most famous footnote in American constitutional law. It is footnote 4 of a case called Caroline Products. In the 1930s, during the New Deal, kind of in the era of the Depression, FDR, the President Roosevelt, had an economic agenda that was essentially federalizing large chunks of the American economy, both to cope with the perceived urgencies of the Depression, but also just to assert federal power over chunks of the economy that had not been considered within the purview of the federal government before. And there were a series of Supreme Court decisions that invalidated portions of Roosevelt's agenda. So Roosevelt says, well, if you guys aren't on board and you're going to keep declaring what I'm doing unconstitutional, I'm going to add I can't get rid of a justice on the U.S. Supreme Court, but I can add a bunch. And I'll just add a bunch of guys that I like, and they'll outvote you guys. And so then the existing Supreme Court justices said, okay, well, we don't want to do this. And so there was a vote switch, and the Supreme Court then started to uphold Roosevelt's economic agenda. Now, in a famous case called Caroline Products, the Supreme Court, in footnote 4, said basically we're going to say there's two kinds of rights in the United States. There are the rights that are contained in the Bill of Rights, the enumerated rights, such as the right to free speech and the right not to be subject to a search that is unreasonable in the Fourth Amendment, things like that. And for all other rights, in other words, unenumerated rights, implicit rights, rights that have to do with equal protection and due process, those are only going to get what is called rational basis review. And rational basis review, which applies to almost all social and economic legislation, means basically if the government goes into court and says, this is why the government did this, if the judge doesn't pass out laughing, then it's upheld. Rational basis review means that the government can rely on completely hypothetical justifications for the law, not the actual reasons, not the demonstrated reasons, not the professed reasons, but just purely imaginary reasons. And so what the Supreme Court was saying is that when it comes to ordinary social and economic legislation, the only limit on government power, essentially, under the Constitution, is the limit of the human imagination, which isn't really a limit at all. So the politically liberal people love this. And they thought, this is great. So there's not going to be any constitutional impediment to working out our economic agenda over the next generations. So a little bit, a few years later, some conservatives were a little bit, skeptical of this, but ultimately conservatives also like power, and that was cemented by a series of constitutional developments that began in the 1960s involving reproduction, and they culminated in the famous case of Roe v. Wade. And Roe v. Wade was this case in which the Supreme Court identified a series of privacy rights that allow women and their doctors to have women to be able to have elective abortions, and it's become a hot button cultural issue in the United States ever since. Now, as a result of Roe v. Wade, conservatives want to put judges on the federal bench who can be relied upon not to strike down abortion laws. Conservatives developed an entire movement based on judicial minimalism, judicial deference to legislators. And so what happened, if you look at the New Deal era theory of the judiciary from the left, and now the conservative theory of judicial minimalism from the right, they converge. And they converge on the proposition that when it comes to regular property rights and economic liberty and other kinds of social legislation, the courts should not be enforcing in any meaningful way constitutional rights against what the government wants to do. And so that explains in why that, well, let me put it this way. One of the principal explanations for why government has proliferated, and proliferated in exactly the way public choice economics describes, is because courts are not doing their job of enforcing economic and property rights of ordinary citizens. And the Institute for Justice is dedicated to moving constitutional law in a more protective direction for those kinds of rights. Now, you can imagine that if you have a constitutional standard that says the government wins just by making stuff up, winning a case like that is, sometimes we talk about it as being a legal equivalent of putting someone on the moon. I mean, it is very, very hard, and it took years and years to learn how to do it. And even then, we can't do it very reliably. But there is a way to do it, and that way is really rooted in our special approach to litigation, which I'll talk about for a minute. A good case is the one Pat mentioned before. Actually, the boxing gym case exemplifies this, and a case that Pat mentioned about the monks also does. So what do you need? I could go in front of a judge and I could say, oh, Your Honor, don't you understand that this economic regulation is completely irrational and that there is a theory of property rights that is X, Y, and Z, and that really we ought to respect the market in this case because, the price mechanism is a way of aggregating the informational interests of lots of people, blah, blah, blah. Nobody pays attention to that. Courts don't care. Nobody cares, and not surprisingly, because it's boring. So what do you need to win a case? You need a sympathetic plaintiff. You need simple facts. You need an evil villain, and you need an outrageous act. Okay? And all of IJ's cases embody this particular model. So a good example is the monks. Now, the monks of St. Joseph Abbey belong to a Benedictine order that is just north of Louisiana on Lake Pontchartrain. I'm sorry, north of New Orleans in Louisiana on Lake Pontchartrain. The monks have had their abbey there for over 100 years, and they have a cemetery on their abbey where they have been burying the brothers when they die. They handcraft caskets. And so then Hurricane Katrina blows through in 2005 and wipes out some of the forest that the monks would harvest from time to time, in addition to the other work they do to support themselves. St. Benedict, 1600 years ago, issued a rule that the monks must be artisans of the monastery. They have to put bread on their own table through the labor of their hands. And so the monks don't get any money from the Catholic Church, so they have to work simple jobs in order to support themselves. So somebody came along and said, your caskets are quite beautiful. Why don't you consider making and selling your caskets as a way to make some money, to replace the lost income from your forest that's just been blown down? And so the monks thought, oh, this is a pretty good idea. We've been doing this for 100 years, and we give caskets away quite often because people like the sort of elegant simplicity of these simple handmade wooden boxes. Caskets, incidentally, don't serve any hygienic purpose at all. A casket is just a box. That's it. You don't need a casket to be buried. You can throw someone in the ground. You can bury them in a bed sheet. It doesn't matter. People are not dangerous when they die. So anyway, the monks think, oh, this is a great idea. And on All Souls Day, November 1st, 2007, the local diocesan newspaper carried a little story about St. Joseph Woodworks. That's what the monks called their business. And they said, we'll sell our simple handmade caskets. Let us know if a person in your family passes away, and we'll deliver a casket to the funeral home. Well, before the monks had sold even one casket, a complaint was lodged with the Louisiana Funeral Board. It's the government bureaucracy that oversees the funeral industry in Louisiana. So I haven't even sold a casket. And a complaint comes in, and the monks get a cease and desist letter from the government telling them that they're out of business. Now, who does that complaint come from? Now, if you're a public choice economist, you know exactly who that complaint is coming from. Now, if you have a kind of naive view of government, you might think that, oh, well, maybe someone in Louisiana government was looking at this and thinking, oh, is there a fraud potential? Maybe I should step in, I should double check or something like that. No, that's not how the world works. Boyd Mott, whose family, he's like a 5th or 6th generation funeral director whose family owns the biggest chain of funeral homes in Louisiana, filed a complaint against the monks because in Louisiana it is, or was, a crime to sell a casket unless you were a state-licensed funeral director. And being a state-licensed funeral director is just a barrier to entry that allows funeral directors to monopolize the market in selling caskets and selling funeral goods and services. It's not surprising that funerals cost thousands and thousands and thousands of dollars, because when somebody passes away in your family, there's only one person you can go, or well, one small group of people you can go to help you with that. By law, it has to be these state-licensed funeral directors, and they weren't about to let the monks get in on their casket selling action, which was going to cost them money. So we thought, this is great. Everybody loves monks. The monks are just sort of like a family. They're a very sympathetic plaintiff, and the facts are very simple. They just want to sell their caskets, these beautiful handmade wooden caskets, to bereaved families. We have an evil villain in funeral directors in general, but this one funeral director in particular, and the bureaucrats who are enforcing the law, and we have an outrageous act. Namely, these guys went into business to support themselves. They call each other brothers. They think of themselves as a big family. It's a family business, and the government shut them down for no reason other than to protect the financial interests of industry, of politically connected industry insiders. This is a perfect case for IJ. And so we're in taking this case, we weren't just trying to vindicate the rights of the monks. What we're trying to do is establish constitutional precedent that will protect entrepreneurs everywhere from these kind of public choice types of laws and legal actions against entrepreneurs. Now, the reason why we need such sympathetic clients is because we're under the rational basis test that I described before. We went into court to say, look, Your Honor, I mean, we're not kids. Everybody understands what's going on here. The government is just enforcing this law against our clients in order to make sure the funeral directors stay as rich as they can be. And by the way, this was one of the things we do at IJ, incidentally, is not just litigate in court, but we litigate in the court of public opinion. And so when we launched the case, we were, my co-counsel and I were on national TV, we're on local TV. We wrote op-eds in USA Today. We've written op-eds about that in the Wall Street Journal. The Wall Street Journal actually did a front-page story on the case. And the funeral, and so we're very sophisticated media-wise because we want to make the government seem not just wrong but fundamentally illegitimate and outrage the public, because then judges sitting in their chambers think to themselves, you know what? If I strike this down, nobody's going to call me a judicial activist. Nobody's going to call me, that I'm overstepping my bounds. So we're very sophisticated in terms of our media presentation. And one of the things we take advantage of is the unsophistication of the other side. People like, the funeral directors and the private funeral director lobby group and the government bureaucrats that were doing their bidding are not used to presenting their case in public. And so one of the funny things is that we had this outstanding front page story in the Wall Street Journal. It's the second largest newspaper in the United States behind the New York Times. And the funeral directors, the reporter said to the funeral director, why can't monks just sell their caskets? I mean, what's going on here? Like, just let them sell their caskets. It's ridiculous. And so they said, well, maybe what problem we got here in Louisiana, the other thing is that only Louisiana basically at this point still had this law. No other states had this law, and there's absolutely no evidence that there's any danger from people selling caskets who are not licensed funeral directors. So then this guy scratches his head, and he says to the Wall Street Journal, well, the problem is in Louisiana, people are so fat here that sometimes we need a professional to make sure that the casket is going to fit our gigantically obese citizenry. And so that was on the front page of the Wall Street Journal. And they, and you can imagine the public is reading this and they're thinking, like, this is ridiculous. You're knocking around the monks, and this guy's called everybody in Louisiana fat, and like we're fat and we're stupid and we can't even buy caskets from monks. And we turned Louisiana funeral bureaucrats and Louisiana funeral directors into the most hated people in the state of Louisiana. The governor, Bobby Jindal, who's ordinarily he's would be very friendly to our ideas anyway, our kind of principled limits on government types of ideas. He wouldn't touch this with a 10-foot pole. He stayed completely away. He let the funeral director bureaucracy bury themselves. But we're still up against a rational basis test, even though we have destroyed them in the minds of the public. And I remember opposing counsel stood up after we did our presentation in court during the trial. Actually, we had a trial. It was great. Got a bus, brought in all the monks in their habits, and everything. They sat in the courtroom. We had caskets in the courtroom so the judge would understand these are just boxes. The abbot, Abbot Justin, who was our lead witness, was wearing his full monastic habit and like a cross about this big. I mean, it was like it covered his whole chest like a, like a bulletproof vest, which in Louisiana matters, incidentally. It seems a little peculiar maybe in Canada, but not in Louisiana. And so it was great. It was like excellent litigation. So then the lawyer for the state, I wish I, especially I'm being taped, so I don't like to mock opposing counsel. But anyway, he had this Louisiana accent. And he tells the judge, he says, "Your Honor, you should throw this case out right now, because evidence doesn't matter under the rational basis test. All that matters is whether we can dream up some reason for this law. Maybe the government thinks that, the monks or someone else like them are going to rip people off, and if we can dream it, that's enough to uphold this law. It doesn't matter that the reason why we're actually doing this is to make funeral directors richer. It doesn't matter." And then he said something that is doctrinally correct, but was irritating, and that was, "Your Honor, if you don't think we, as government counsel, have done a good enough job dreaming up some hypothetical justification, the Supreme Court requires you, Your Honor, to dream up your own justification for this law in order to rule for the government." In other words, the rational basis test is so bad, the Supreme Court has said, judges have an affirmative obligation to sit down with defense counsel and actually try to dream up reasons why the government should win. Now you understand why these cases are so hard to win and why we need very special facts, and we have to litigate them just right. I mean, we just agonize over every detail, sit-ups the middle of the night, and we're just agonizing over every detail to make sure it's just right. So the judge, in the end, the trial judge just said, "You're right, this is unconstitutional." Even though the rational basis test suggests that there are no limits on government power, this is just one step too far for me. The Constitution has to have some limit, and telling these monks that they can't run a harmless business just to protect politically connected industry insiders, that is an illegitimate use of government power. And that was outstanding. So that's great. So we won in front of the trial court. Then the funeral directors go crazy, and they're going to appeal to the United States Court of Appeals for the Fifth Circuit, which is the appellate jurisdiction that covers Louisiana, Texas, and Mississippi. So we go up to the Fifth Circuit. Again, we get the bus and we tell the monks, like, we need monks and we need nuns. So we get some nuns to come too. And so we pack the Court of Appeals with monks and nuns on one side, and then the other side are these like sinister looking funeral directors kind of sitting here like this. And so we've got our nuns, we've got our monks, it's great. And the argument's going well, but then one of the judges starts talking about, well, I mean, the way things, I think it basically works the same. You have when you go up on appeal in Canada, I suspect it's the same. You sit in front of a panel of appellate judges. They have a fixed record from the trial court, and then they're discussing the legal propriety of the judgment below. You don't consider evidence anew or something like that. But anyway, one of the judges starts talking about maybe there's going to be a funeral chop shop or something like or a casket chop shop, meaning that, well, maybe the state wants only funeral directors to sell caskets to make sure that there isn't some kind of almost like maybe cars or something, or caskets are taken and chopped up and reassembled in some garage somewhere and they're of poor quality. Forget the fact that there's no evidence in the record that this exists anywhere in the United States. The question was never raised in the trial court, so we didn't have an opportunity to really even address it. But under the rational basis test, this federal judge, in the middle of oral argument, just starts spinning out some scenario about funeral chop shops and that kind of thing, and that maybe the government has an interest in preventing that. And the only thing you can do is sort of, stay cool under fire and say, that is just so implausible that it is beyond the reach of even the rational basis test. And that courts should not ignore the context in which these laws arise and are enforced. And in this particular case, the evidence shows that we have refuted every even hypothetical justification for the law. So then the judges, they go back, and we're thinking, we think that went pretty well. We had our monks and our nuns and everything like that. Even though these cases are supposed to be impossible to win, we think we're probably going to win this. And then they issued a funny ruling, and they asked the Louisiana Supreme Court to weigh in. The way things work in the United States, you have the federal judiciary, then you have state judiciaries. When federal when federal courts are ruling on matters of state law, such as the constitutionality of a state law, if the federal court has a question about the meaning of the state law, it can ask the state Supreme Court, which is the authoritative enunciator of the meaning of state law. And so the Fifth Circuit, our panel in the Fifth Circuit, asked the Louisiana Supreme Court, hey, does this funeral law really allow the funeral directors to prevent the monks from doing this? Because we could, if we squinted at it, we could read it one way, that maybe the law doesn't even allow Louisiana to exclude the monks. And the reason why the Fifth Circuit did this is that striking down an economic regulation is so anathema to judges under the rational basis test. It happens so rarely that they couldn't bring themselves to pull the trigger until they were absolutely certain they had exhausted every alternative to rendering a constitutional ruling. There's a doctrine, I'm sure there's a counterpart in Canada, a doctrine called constitutional avoidance in the United States, which says that if a court can reach a judgment on grounds other than declaring a law unconstitutional, the court should endeavor to do that in order to avoid a constitutional ruling, which is itself a kind of mini crisis of democracy, because an unelected judiciary is invalidating a law promulgated by a democratically elected legislature. So the Louisiana Supreme Court, after about a month, wrote back and said, we refuse to give you an opinion. Basically what they said is, you have eviscerated the funeral directors in the court of public opinion. You have litigated this case. Everybody hates the funeral directors, and we as the Louisiana Supreme Court are simply not going to weigh in. That was the subtext of that. And so then it was back in the hands of the Fifth Circuit, and they actually had to make a constitutional decision. And they ruled in our favor, which was great. And so and not only did they rule in our favor, but they said, the rational basis test, there are limits on what the government can do and the arguments that the government can make even under rational basis review. And this is the strategic part of IJ's mission, because this case now, even though it's just about monks and seems like an exotic case, the substance of it was about the constitutional standard. And we have shifted that constitutional standard. This is a test case that will now be cited in courts. It is binding precedent within the Fifth Circuit and will now be cited by federal courts and state courts across the country for the proposition that if you can go into court and prove that the government is regulating you just to make industry insiders rich, that is an unconstitutionally illegitimate use of government power. Now, the Louisiana and its funeral directors weren't about to take this lying down, so they petitioned the U.S. Supreme Court for review. And I wrote 2 responses. When a case is about to go up to the Supreme Court, the other side is petitioning. You don't have to respond unless the Supreme Court orders you to. And we had actually considered maybe responding affirmatively, because one of our objectives, our institutional missions at IJ, is to advance everybody's rights. And the best way to do that is by putting questions in front of the U.S. Supreme Court and getting a decisive ruling from that body. And so then a lot of sort of weird stuff goes on, behind closed doors for us. We start counting votes on the Supreme Court. Supreme Court is a very conservative institution in the United States. It is, the present Supreme Court is the result of 35 years of conservative legal activism inculcating a judicial culture of minimalism and deference to legislatures. And so we have to make strategic decisions. And I actually drafted 2 versions of a response, because to be honest, Louisiana's petition wasn't very good. And so we thought it's very improbable that the Supreme Court is going to take this based on the petition that Louisiana did. So if we want the case to go up, we probably have to kind of take an affirmative step and maybe draft a compelling response suggesting to the Supreme Court that it should take the case. We wrote 2 responses, sort of didn't like them, did the vote counting, we weren't really sure about it, and ultimately we decided not to do anything, and the Supreme Court denied review, so the case is over. It just ended a few weeks ago. And we won, and it was a great victory for the monks. It is a great victory for entrepreneurs across the country, especially grassroots entrepreneurs, who will now have a decisive statement of constitutional law against the kinds of laws that are routinely written to disadvantage ordinary entrepreneurs. So that's how we do strategic litigation at IJ, and it's really fun. Unfortunately, they have some organizations in Canada that try to do it. One of the big issues in Canada is that if you lose a case, the government can seek fees from you. Government can't do that in the United States. And so, you know, we can go up against them without bearing the risk of having to pay their fees if we don't prevail. And that's what makes our litigation possible. We have a dedicated group of supporters at IJ, thousands of donors who support us in our mission, which is extraordinary. But I do as much as I can to sort of offer advice and counsel to our Canadian counterparts to sort of help them out and do the kind of cases that are going on here. So with that, I will wrap things up. And if you have some questions about the things I've discussed, or if you just sort of want to riff on American constitutional law and ask me if you think that, you know, should this be unconstitutional or is this law unconstitutional, I'm happy to chat about it. So thank you.